Hey guys, it's Leah Buckles from Prestige Veteran Medical Consulting. I'm a U.S. Army veteran, physician assistant, and former compensation and pension examiner. I wanted to come on and do a quick introductory video to a recording that I recently made with my good friend Garen from VA Appeals. He's an accredited claims agent able to represent veterans across the country in their appeals and actions against the VA for their disability claims. So we made kind of a longer video and it wound up being so fantastic that I cut it up into several videos and segments. So this intro is to lead into his commentary on supplemental claims and how those can play a pivotal role and part in your claims process. So I hope you guys enjoyed this part of the video, and please drop some comments, and thanks for watching.
Precisely. Very well said. The next one is supplemental claim, and I do like this. I mean, I said there's plus and minus with the AMA, Appeals Modernization Act of 2019. This is a plus because the supplemental claim can reflect a decision that was made back in 2007. I have several clients that I've filed supplemental claims. It's in the past, it was filing a notice of disagreement. That was the nomenclature for arguing against a denial. NOD, notice of disagreement. That's all changed. NOD does come into play on the BVA selection, but with the supplemental claim, at any time, it can exceed the 1 year, which is kind of the statutory limit in most instances, you can open up a supplemental claim going back to your decision after you retired in 2007. I'm thinking about a client I have right now that we just did this for. You can do that. Here's the difference. With the supplemental claim, you are required to submit new and material, change of words, now it's new and relevant evidence. Mm-hmm. That means something you haven't seen before being new. And relevant used to be the word material, which is a legal term, but now relevant means, is this information you're providing us, the VA, going to change the outcome? Is it going to change our minds that you were correct and we're wrong? So you have to have some evidence to submit. And I'm going to put in a plug here because this is the importance of providers like Prestige Veterans. You get to that point as you plan this out, whether you're by yourself or you hire a claims agent or an attorney, you need to know in advance there's a requirement. I got to provide them something fresh, something that could change their decision, change their mind. How do I get that information? Maybe I look through the medical record and find something they didn't see. That would be new because they hadn't seen it before, even though they're supposed to do the total review of your medical record. Or relevant, meaning, I've got new evidence from Prestige Veterans, for instance, that says there's a causal connection between my low back pain and my right hip pain, a hypothetical, people. Mm-hmm. You need something new and something that's material in order to file a supplemental claim. Pretty clear?
Absolutely. So can things like a migraine buddy log be new and material medical evidence?
For sure. That's actually very good evidence. Lay statements are given as much weight as a medical record sheet, a progress note. Lay statements, as Leah just said, can be from a spouse. Maybe it's a buddy statement from somebody that was in combat and saw you get that bonk on the head. Mm-hmm. Keep this in mind as we go through as the VA goes through the process of developing your claim. They're going to look for, again, from the outset, is it well-grounded? Did something happen in service? Is it bothering me today? And is there a nexus or a causal connection between the two? Mm-hmm. That's called well-grounded. And a claim has to be well-grounded or you're not going to have success. Then they have to assign weight. If you went to a C&P examiner, and Leah, as you know, is a former C&P examiner, she knows all about that process. That person, man or woman, could be a nurse practitioner, could be a medical doctor, could be a psychologist, is going to look at everything and write up a report. It's called a DBQ now. Disability Benefits Questionnaire, submitted to the VA. So the VA gets that, and they put it on one side of the scale. You submit something from Prestige Veterans or some similar outfit, you've got your evidence on this side of the scale. Without anything more, if the VA is negative, opposed to your proposition, but prestige veterans evidence is positive. That means the scale is even, or in what they call equipoise. All right, that means they're not going to give any more weight to one or the other because you only have two pieces of evidence. Guess who wins? Under the reasonable doubt doctrine 3.102, you win. Because if the evidence isn't equipoise, the grant must be in favor of the veteran. Keep that in mind. Very important. You want to submit as much evidence. So you got, let's say, a report from Leah's business, Prestige Veterans, and you've got a buddy statement saying, I think you mentioned the migraines, saying, yeah, Joe, my friend Joe had migraines, and I know because I saw him taking medicine, and sometimes he'd lay prostrate on his cot and he couldn't go to work. Now you got two pieces of evidence on your side of the scale. So that's what supplemental claim does. It affords you an opportunity to introduce new evidence to hopefully overcome whatever was on the VA side of the scale, which caused them to make a denial.
Sure. So, and keep in mind that this is all the way that, as Garen laid out, that it should go. It doesn't always go that way. Unfortunately, the adjudicators are human. Mistakes can be made, unfortunately. And that's where having a good guide, a good legal professional like Garen, an accredited claims agent, an attorney, even a great VSO can be helpful. You can, of course, do this on your own. If I'm not mistaken, Garen, the veterans can represent themselves in this process. But if they feel that they've been getting like roadblock after roadblock, or perhaps they don't want to do the heavy lifting, I always say, could I change, a diesel engine out of my truck with the manual and try to figure it out and buy the tools and do it? Absolutely. Or would I want to just go to a specialist that can assist me? It's all personal preference. There's no, it's up to the claimant to decide. But that's why I always urge people to seek that legal guidance, because you have such a wealth of knowledge. Like with Garen, he's been doing this for so long, he can spout off these regulations like the back of his hand, right? So keep that in mind, veterans, that you have advocates that can assist you with this process.
And that's a great analogy. I like your engine rebuild. That's a great analogy because, yeah, pretty much all of us are capable. And guess what? As I said, va.gov is all the information you're ever going to need. All right. It's 38 CFR, Code of Federal Regulations. All right. You can look it up online. All that is there. It's a matter of, do you have the time and do you have the tools you need to make it apply to your situation? That's why we help one another. That's why there's outfits like Prestige Veterans that are going to provide that integral piece of the puzzle that's going to fit in, and the VA is going to have no choice to make a grant. At least that's what we hope.
Yeah.